Welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Today, we're going to discuss important issues appearing in the Hindu newspaper dated 10th March 2018. Let's begin. Today, the issue of euthanasia has been covered throughout the newspaper. It appears on page number 1, page number 5, and also as an editorial on page number 6. On page number 1, the news reads, Supreme Court upholds passive euthanasia. Here, the Supreme Court says, Constitution bench allows living wills with safeguards. The Supreme Court further holds that right to die with dignity is a part of basic right to life and says that quality of life is as important as prolonging it. Similarly, this news reads, endless life support is inhuman, and here it reads death with dignity, where the court has laid down a much needed legal framework for enforcing living wills. So let us understand this news with respect to euthanasia. So what is the news? Here, Supreme Court in a 5-judge constitution bench has laid down broad legal framework to protect the dignity of a terminally ill patient or those who are in persistent vegetative state with no hope or cure of recovery, and in the process has allowed passive euthanasia and also allowed the right to give advance medical directives or a valid living will so as to smoothen the dying process as a part of fundamental right to live with dignity. Earlier, the concept of passive euthanasia was recognized by a 2-judge bench in Aruna Schonbach case in the year 2011. Now, the Constitution bench has expanded the scope of euthanasia by adding into it the concept of living will or an advance directive, a practice where a medical patient, while in a competent state of mind, leaves written instructions for medical treatment which may or may not be administered to him on reaching a particular stage of illness. This living will shall also contain the name of the legal guardian or a close relative who shall be giving the go-ahead for starting passive euthanasia. So far we have seen what the 5-judge constitution bench of the Supreme Court has held. It has laid down broad legal framework for protecting the dignity of terminally ill patient and those in persistent vegetative state, and has also allowed the case of passive euthanasia as well as allowed the right to give advance medical directives or a valid living will. So in this respect, let us understand in this news analysis the following so as to better understand the entire concept of euthanasia. Thus, let us understand the meaning of euthanasia, the different kinds of euthanasia, the current judgment of Supreme Court, successive judgments on the concept of right to die, and doctor's call on passive euthanasia, or what shall be the duty of the doctor in case of initiating passive euthanasia. Let us understand all these different issues one by one. As we see, the Oxford Dictionary meaning of euthanasia is painless killing of a patient suffering from an incurable and painful disease or who is in an irreversible coma. So euthanasia is at times also referred as mercy killing or even physician assisted suicide, and can be described as bringing about the gentle death of a patient suffering from painful, chronic or incurable disease. So after understanding the concept of euthanasia, let us also understand what are the different kinds of euthanasia. The first kind of euthanasia which we come across is active euthanasia versus passive euthanasia. As we see, active euthanasia means or occurs when the medical professionals or another person deliberately do something that causes death of the patient. Example, when a person is killed by an overdose of painkillers. Whereas passive euthanasia is when death is brought by an omission. That is, when someone lets the person die. Now this can be done by either withdrawing or withholding treatment. By withdrawing treatment, we mean switching off a machine that is keeping a person alive, and withholding treatment means not carrying out any surgery or any medical process which may extend life for a short time. Now let us understand the difference between voluntary euthanasia and involuntary euthanasia. Voluntary euthanasia occurs at the request of the person who dies, and non-voluntary euthanasia occurs when the person is unconscious or in a state where he is unable to make a meaningful choice between living and dying, and a different person or a different appropriate person takes the decision on their behalf. Non-voluntary euthanasia also include cases of children and decision on their behalf is taken by their legal guardian. There is another concept of indirect euthanasia. Let us understand. This means providing treatment to a patient whose side effects accelerates his death. In the case of indirect euthanasia, the primary intention is not to kill the patient. So after understanding all these differences of indirect euthanasia, voluntary and involuntary euthanasia, as well as active and passive euthanasia, now let us understand what did the Supreme Court in the recent 2018 judgment has said on passive euthanasia. As we have seen earlier that the Supreme Court had allowed passive euthanasia and also allowed the right to give advance medical directive or allowed the concept of valid living will. Now in this part, let us understand the reasons given by the Supreme Court where it allowed both passive euthanasia and also advance medical directive. The Supreme Court said that fundamental right to life and dignity under Article 21 of the Constitution also includes right to die with dignity. Earlier, this concept of right to die with dignity was never a part of right to life under Article 21 of the Indian Constitution. So, this marked a major difference from the earlier decisions of Supreme Court. The Supreme Court further held that dignity of a person is lost if a person is allowed or forced to undergo pain and suffering because of unwarranted medical support. The court said that depriving a person of dignity at the end of their life is equivalent to depriving him of a meaningful existence. And in this respect, meaningful existence includes a person's right to self-determination and autonomy to decide his medical treatment. And agreeing to this, the court further said that right to a dignified life also includes a dignified procedure of death. While giving out the reasons for dignified death, Supreme Court further distinguished passive euthanasia from suicide and active euthanasia and drew a judicial line between the two. And while distinguishing passive euthanasia from active euthanasia and suicide, it called passive euthanasia as a mere acceleration of the inevitable conclusion and declared active euthanasia as unlawful and also said that suicide involves overt acts which culminates in an unnatural death. While declaring all these judgments, Supreme Court has also invoked its inherent power under Article 142 of the Indian Constitution to grant legal status to its advance directives until Parliament enacts legislation on the matter. Article 142 of the Indian Constitution talks about enforcement of judgments of Supreme Court throughout the territory of India. Now this is a landmark judgment and it departs from various previous judgments on the concept of including right to die with dignity within the larger ambit of right to life under Article 21. So let us understand what the previous judgments were and how this concept of right to die has been slowly incorporated within the concept of right to life and personal liberty under Article 21 of the Indian Constitution. Now let us see how the discourse on the issue of right to die has changed over successive years through different judgments. In India, various attempts have been made in the past to include right to die within the concept of right to life and personal liberty, which is a fundamental right under the Indian Constitution. In Gyan Kaur versus State of Punjab in the year 1996, a 5-judge constitution bench held that the right to life is inherently inconsistent with the concept of right to die, as is death inconsistent with life. The constitution bench further said that right to live with human dignity would mean the existence of such a right up to the natural end of life. The court further stated that issues like suicide, euthanasia, and mercy killing amounted to unnatural ending of life, which is very different from the concept of right to live with dignity, as according to the constitution bench, right to life with dignity would mean existence of such a right to the natural end of life. And here the court stated that examples of suicide, euthanasia, mercy killings amounted to unnatural ending of life, thereby distinguishing between right to life and right to die. Thus, this was a very important case, that is Gyan Kaur versus State of Punjab in the year 1996, where the Supreme Court in a 5-judge constitution bench categorically said that right to life does not include right to die. Thus, through the judgment in Gyan Kaur versus State of Punjab, it effectively overruled a previous judgment of P. Ratinam versus Union of India, which recognized right to die within the concept of right to life under Article 21 of the Indian Constitution. Now, a major breakthrough was achieved in Aruna Schonborg case. Aruna Schonborg suffered brainstem and cervical cord injury and remained in persistent vegetative state for the rest of her life since she was admitted in the hospital in 1973 till her death in 2015. In the year 2009, a writ petition was filed under Article 32 of the Indian Constitution. That is, a writ petition was filed in the Honorable Supreme Court of India. And the writ petition sought passive euthanasia for Aruna Schonborg. In a landmark judgment in the year 2011, Supreme Court allowed passive euthanasia and asked the doctors at KEM Hospital, Mumbai to stop force feeding her and also to withdraw life support to deliberately end her life on the discretion of the doctors. Thus, through this judgment, the Supreme Court allowed withdrawal of life-sustaining treatment from those patients who were not in a position to make informed decisions. This was the first time after Gyan Kaur case when the Supreme Court allowed passive euthanasia under strict guidelines and conditions. However, even in this case, Supreme Court did not allow active euthanasia and held that ending life through use of lethal substance is not permitted in any circumstances. With the following judgments, you would have understood how the Supreme Court moved from the case of Gyan Kaur versus State of Punjab, where it did not include right to die within the concept of right to life, and from then in the Aruna Schonborg case in the year 2011, where in a landmark judgment the Supreme Court effectively allowed passive euthanasia and allowed the withdrawal of life-sustaining treatment from those patients who are not in a position to make informed decision. Thus, with this, we understand how the discourse on issue of right to die has changed over successive years. Now, let us understand doctor's call on passive euthanasia. In this, once the doctor is satisfied that there is no cure, the doctor should give due weight to the instructions left by the patient in their living will. After the doctor decides that the living will needs to be acted upon, it is the doctor's responsibility to convey the guardian or close relative about the medical condition of the patient and availability of medical care, consequences of alternative forms of treatment, and also the consequence of remaining untreated. The doctors will then have to constitute a medical board consisting of head of the treating department and at least 3 experts having 20 years of experience. And these 3 experts can be from the field of general medicine, cardiology, neurology, nephrology, psychiatry, or oncology. In case the medical board decides not to follow a living will, then it can apply to the district collector concerned. And if the medical board decides to apply the living will, that is, to allow passive euthanasia, then also it has to inform the district collector. Then the district collector will also form a medical board with the chief medical officer as the chairman to endorse the decision on passive euthanasia. Thus, you have seen all the issues as discussed in this news pertaining to the meaning of euthanasia, kinds of euthanasia, that is active as well as passive, and voluntary as well as involuntary. Current judgment of the Supreme Court, which effectively enlarged the concept of right to die with dignity. We also saw successive judgments with respect to judgment of Gyan Kaur versus State of Punjab as well as the Aruna Schonborg case, where effectively in the Aruna Schonborg case in the year 2011, Supreme Court allowed passive euthanasia, and we finally saw doctor's duty on initiating the process of passive euthanasia. Thus, I hope this topic effectively clears all your concept on euthanasia as well as different kinds of euthanasia and what the Supreme Court had to say on the case of passive euthanasia. Now, this topic has a wide-ranging concept. This topic includes both from the polity section as well as from the social issue point of view. Such topics can also be asked in the essay paper. Thus, it's very important to understand, since this is a landmark judgment on passive euthanasia, hence it becomes very important not only to understand the concept of passive euthanasia but also what the decision of the Supreme Court was on previous occasions. I hope this would have cleared most of your doubts with respect to passive euthanasia. With this, let's move on to the next news. Now we come to page number 6 in the editorial section. Here, the news read, Trade goes on. The revival of Trans-Pacific Partnership sans US must buttress the free trade debate. Here in this news, 11 Asia Pacific countries, including Japan, Australia, and Canada, have signed a comprehensive and progressive agreement for Trans Pacific trade. The aim of this comprehensive and progressive agreement is to slash or reduce trade tariffs and non tariff barriers. This agreement by the 11 countries was signed in Chile, a country in South America, and whose capital is Santiago. Now, as we know that this Trans-Pacific Partnership Agreement was a trade agreement between 12 countries that border the Pacific region. And among these 12 countries, US was also one of them. One of the main aims of this Trans-Pacific Agreement was to cooperate on economic policies as well as regulate tariffs. This trade agreement, that is Trans-Pacific Agreement, was backed by United States of America during the presidency of Barack Obama. However, this Trans-Pacific Agreement of late has been opposed by the current president of US, that is Donald Trump. But the Trump administration did not merely oppose Trans-Pacific Agreement but eventually made United States withdraw from the Trans-Pacific Agreement. However, the important thing to note here is that despite US opposal as well as withdrawal from the Trans-Pacific Agreement, 11 Asia-Pacific countries, including Japan, Australia, and Canada, have signed this comprehensive and progressive agreement. And this agreement, signed by 11 countries, effectively look forward to the future in a post-Trump era, where there is a possibility that US might again come back or join back in the Trans-Pacific Partnership Agreement. So this agreement by 11 countries shows that the world is still open to free market trade, even with US absence or its opposite. Thus, this topic becomes important from an international relation perspective of UPSC. With this, let's move on to the next news. Now we come to page number 9. Here the news reads, Rajasthan passes a bill to give death penalty for child rape. In this news, Rajasthan government has passed a bill, namely Criminal Laws Rajasthan Amendment Bill 2018. The bill aims to convict those people who rape girls of 12 years or below that age. And for this, the state of Rajasthan has passed this bill to amend Indian Penal Code by inserting two new sections, namely Section 376AA as well as Section 376DD. Now in this Section 376AA provides for capital punishment or rigorous imprisonment. And this rigorous imprisonment shall range between 14 years to lifelong incarceration. That is, from 14 years to lifelong. Whereas Section 376DD provides for similar provision, that is, capital punishment as well as rigorous imprisonment for gang rape of such girl child who is 12 years or below that age. And in this respect, rigorous imprisonment shall range from 20 years to lifelong incarceration. In this respect, you should know that Rajasthan becomes the second state after Madhya Pradesh to pass a similar bill to provide death penalty who rape girl child who are or below the age of 12 years. And this bill will become an act when signed by the President of India. So in this news, it's important to understand the various amendments as proposed by the state of Rajasthan. Now the bill proposed by Rajasthan will have a deterrent effect on such criminals. Thus, this topic becomes important with respect to the amendment proposed by state of Rajasthan with respect to providing capital punishment for raping girl child of age of 12 years or below that age. With this, we come to an end to today's newspaper. Let's move on to the question for the day.